Well, what happens? There's feedback on the mic if I. All right, you guys there? Hello, hello.
They gave up on you.
Hey.
Oh no, they didn't give up. I hear one person that sounds like Think Missa.
I heard Mike too.
Regular.
All right, cool. Hey, Mike, how's it going, man? And who else do we have? Michelle G. All
Oh,
right.
wait, maybe I thought Mike.
So who's first?
Dibs.
All right. Well, somebody speak.
I have some questions kind of extending from last week.
Yeah, go ahead. Shoot.
So I looked over Rule 28 or FRCP Rule 28. What is this?
FRCP Rule 28. Hold on.
Oh, sorry. I skipped too far. Rule 35A.
Hold on. CP. I don't know that off the top of my head, so I got to look it up.
So this is about the oaths and affirmations.
Oh, what the fuck? What is going on here? Hold on. Ah, he's got me set up with that crazy Surfshark thing. I hate that. So FRCP. What'd you say? 35?
30. And it's 5A.
So FRCP Rule 30.
Uh-huh.
All right. Ah, Jesus. Hold on. James. This sucks, man. He has this Surfshark thing set up, so I gotta go through this rigor every single frickin' time that I get on the net now. It's like, come on, man. Alright, FRCP Rule 30. Oh, you're talking about depositions, yeah?
Yes, so extending on last week's question.
Okay, let me get to Rule 35, officer's duties. Yeah, go ahead.
So the question is, so 5A, so before the deposition, so the first line or the first text there says, unless the parties stipulate otherwise.
Right.
Could that imply that me and the opposing counsel can agree to allow me to administer the oaths prior to the deposition?
No.
Okay.
No, what it's talking, whoever's going to administer the oath has to be somebody, duly licensed under the state of California's rules to administer, or whatever state you're in, actually. I mean, this is federal, so you're in California, so it'd be under California rules to administer the oath. You're not so qualified. Secondarily, you're never going to get, what they're talking about here is that by stipulation with the other side, you can waive the oath. Right? Oh, okay. No, I see what you're talking about. It's an officer appointed. Yeah, I guess it does. I'm reading it right now. Unless the parties stipulate otherwise, deposition must be conducted before an officer appointed or designated under Rule 28. So I guess that means that you don't necessarily, if the other side will agree, then you don't have to have somebody administer the oath.
Okay, so extending out to that, if we can go look at Rule 28.
Uh-huh.
And so this is A1B, and it says a person appointed by the court where the action is pending to administer oaths and take tests can also administer them. So alternatively, if the other side doesn't agree, could a hypothetical request or motion to the court be made asking the court to allow me to do that?
Yeah, the court's never going to allow you to do that.
Got it. Okay, those are my questions.
You're not ever going to get out from under having a certified court reporter administer the oath and take the deposition. Unless the other side agrees, I can guarantee you that the other side is never going to agree to let you do that. Part of the game is to bleed you out, right? And if they're helping you do things to save money or to make things easier, they're not bleeding you out.
Right. So that's why they wouldn't. What about the court? Why wouldn't they?
Because you're not a licensed person, you're not qualified to administer the oath, and it sort of undermines the sanctity of the court process. The judge is never
Right.
judge is never going to let you do it. I wouldn't even waste my time on it.
That makes sense. I at least had to ask.
Yeah, no, that's fair.
So those are my questions for the week.
Okay. Anybody else?
Hey, Sean.
Is this Don or is this Mike? I guess this must be Don because it looks like Mike's muted.
Hi, hi, Sean. This is Don. Good evening.
How's it
Listen,
going, man?
I'm sorry. I hope you.
Yeah.
A specific question here.
Can you adjust your mic? You're coming through really garbled and unclear. I can hear like every third syllable.
I don't know that I can. Let me see. I'm going to hold it closer to me and see if that solves the problem.
That sounds much better.
Thank you, and I apologize. So, Heck v. Humphrey. Does Heck have implications in these wrongful removal cases?
Potentially. It depends which one you're talking about. I think the piece of Heck went up to the U.S. Supreme Court, if I remember correctly, but that was just the attorney's fees against who? Was it the attorney's fees against the county, I think, that went to the Supreme Court? But what happened? So, go ahead.
The part I'm talking about is this. In a non-CPS 4D context, let's say you've got law enforcement misconduct you're alleging, wrongful prosecution, what have you. Heck stands for the proposition that if the criminal case goes to, if there's a conviction,
Yeah.
whether by plea or jury trial.
Oh yeah,
then,
you're talking about the Supreme Court version of Heck. There's another Humphreys that I was confused with. It's also went to the Supreme Court, but it was a 1983 based essentially on defamation. It was like stigma plus. But Heck v. Humphreys is what you're talking about, and what they dealt with there is the intersection between 42 U.S.C. Section 1983 and the federal habeas right to petition for habeas corpus. And basically what the idea is that came out of Heck is that while you've got a conviction, you're incarcerated, let's say, on a conviction, you can't bring a 1983 challenge against the people that got you convicted. I guess that's an easy way to put it. So if there's, for example, some sort of deception in the process, in your process of getting convicted, whether it be at your preliminary hearing or somewhere else, until you get that conviction either overturned or wiped out in some way, then you really can't pursue your 1983 claim. But what courts have interpreted that as is really a tolling statute, meaning that until you get, your conviction dealt with, your statute of limitations on your 42 U.S.C. Section 1983 claim is tolled, right? So that's one way of looking at it. Now, there's some authority out there to suggest that Heck really just applies to the period of incarceration, meaning that if you're no longer incarcerated under your conviction, you may still, be relieved from Heck, meaning that your statute of limitations then may begin to run. But that's, I think it's like 7th Circuit, 10th Circuit, or maybe a 9th Circuit case that says something like that too. It's been a while since I've had to deal with a Heck issue. I don't know if that answered your question or not. Did I lose you?
Should give an example in my case where I got unconvicted.
Don? Well, you have an appellate issue. Your judge didn't buy it. I think that I lost everybody. Mike, can you hear me?
I can hear you. Can you hear me?
Yeah, I can hear you. I lost Don.
Okay.
Yeah, he might have been having some connection problems, though, because at least at the beginning, his voice was coming through really garbled. So what do you have going on? I see in your chat, it's you got a hearing on Tuesday for your defamation suit. What's the
yeah. That's what I was going to ask you about. What if I don't know if you've ever been involved in one, but what can I expect at it's called the Case Management Conference?
Oh,
Some questions.
the judge is going to want to set dates, trial dates, cutoff dates, stuff like that. Case management conference. Once you have everybody served, there's a
Uh-huh.
statutory window. There's a time period in which they need to go ahead and schedule the events in your case out with the ultimate goal of getting you to trial. So
Okay.
you're gonna need to be able to explain to the judge the basis for your case. You know, is there anybody you haven't served yet?
No, everybody's been notified.
Well, notified or served?
Served and responded.
Okay, they served and responded. Okay, so that's not going to be an issue. Normally, if there's unserved parties, the judge will give you crap over that and make you explain why you haven't got them served. They'll probably have you dismiss your DOE defendants if you have any. If there's a good basis not to do that, you'll want to let her know and be prepared to explain yourself. And
What's a
then,
DOE defendant?
that's where you don't necessarily know. You know that people were
like
involved.
no.
Yeah, exactly.
Okay, yeah,
You
yeah,
just don't know their
yeah.
names.
No, yeah, that won't be an issue. I know everybody involved.
Okay, yeah. Well, she may ask you to explain to her what your discovery plan is. You know, when you're going to get your written discovery done, what's your plan with your depositions? Do you intend to file any motions? If so, what and when? And
I sent out the discovery, and then they, sent it back because I didn't have the right format, which is, cool. Play the game. So I did look that up, and I put it in the proper format with the, maximum required or allowed questions to be asked,
mhm.
and which is kind of cool because I liked my second draft better than my first draft anyway. So a lot of the first draft was just, a duplication of questions. So I was able to, fine tweak it really straight to the point of what I was, after. So that kind of helped me out on that one.
Good.
I haven't got a response on the second discovery notice that I sent because the 35 days isn't up yet. It'll be a couple days after the hearing, so I don't really have any motion to compel argument right now because they're still within their time frame.
Right.
But depositions, I really don't really need to do that. It's just one person who I'm, putting on notice. So, I should get everything that I expect not to get do with the discovery requests, and that should cover, that aspect for me.
Yeah, well, you just be able to explain it to the judge. You know what you think you need in terms of time and discovery, and then
Okay.
from there, the judge is going to figure out trial dates, and then all of your cutoff dates will back up from your trial date.
Now they did say that they'd like to try to send us to alternative
Yeah,
dispute resolution.
Sure.
So I'm since we both agreed to do a particular style of that, I'm sure that'll probably be something that'll be ordered out to attempt.
Right. The judge will ask you
Okay.
about it. You'll need to be able to tell the judge, whatever agreement you've got. And I don't know in your particular court, every court's a little bit different how they set it up. They may have their own like volunteer lawyer program or retired judges that'll do, evaluation.
They have a list that they provide us because I've already got the paperwork. I'm already expecting to do it, so I like to stay a little bit ahead of the game. So I was in the law library at the court office, and they recommended this individual who comes really highly recommended and is said to be truly fair. So I requested this individual. I haven't submitted the paperwork yet because it hasn't been ordered yet, so you can't submit it till it's actually been ordered. So I'm hoping that we can get it all resolved in that. And I did hear back from the insurance that they had. I really just kind of strung them along. I really didn't, give them anything of any request that they, were asking me of.
Uh-huh.
They kind of just moved. They just kind of moved along on their process. So I don't know, if they might come at me with something. I don't know how an insurance can try to resolve a, lawsuit that hasn't been ruled on yet, though. That's kind of weird.
Oh no,
They might want
they always do that. In fact, most lawsuits, at least most civil lawsuits, probably 95% of civil lawsuits, especially the kind that you're doing here, resolve short of trial. And the way they resolve is they get settled. Usually,
Okay.
some die the judge will kill some by summary judgment or demur or some other dispositive motion, but the vast majority end up getting settled short of trial. And the way that ends up happening, a lot of them have insurance. The insurance will come in, they do their own assessment. They're not really worried about, what the parties are saying. They'll look at it themselves, and then they'll assess a value, and then they'll offer to pay that value, whatever it is they think it's worth. And
Now, in my case, I'm not really after the money. I know you have to state that in order to file the complaint. I really need a statement of retraction. Can that be negotiated in a insurance settlement? Can they be like, oh, we'll give you X amount of dollars, and then can I be like, well, I need X amount of dollars and this, statement of retraction?
this is the problem that you're going to have, is that the insurance carrier can really only give you what a jury can give you, right?
Right.
And the only thing a jury can really give you is money.
They can't force them to
Nope.
retract the statements.
Nope. But you
No.
could get, if I don't know if you pled a declaratory relief action, but you could get maybe like a judicial declaration, saying, whatever it is that you want done.
I mean, I stated that in the complaint, but I don't know if that was something that is.
So why do you need a retraction? What's the defamatory statement that,
Because the agency, the bureau, made I would say 90% of their actions against me based on these allegations by the caregiver. So I'm trying to get that pulled out so that when I go to the court on the federal civil complaint against the bureau, I'm trying to get them kind of jammed up for not doing their due diligence to, validate all of these actions and instead of taking them at face value and, causing me, extreme.
Well, I think your best bet on that is just depose the lady. You're probably not going to be able to get her to retract anything. All you can really get in your civil suit is money.
Gotcha.
She may be willing to retract the statement to get rid of the case, but then it's going to be, under threat of litigation. So what's the value of that retraction? I don't know. Your better bet, if you're looking at this for some sort of collateral purpose, like an evidentiary purpose to use against the government in your federal suit, the better bet might be to just depose her. You get to depose her once here in your civil case, and then in your federal case, you're going to get to depose her again, right?
Makes sense. No, yeah, definitely.
Yeah, so it's a little bit expensive. That's kind of an expensive solution,
right.
But you're going to have her under oath, talking about the same shit in two different cases, and if there's any variance, then, maybe she's a liar, right?
Right.
So that
Gotcha.
that might be the better approach, is don't settle anything until you're able to depose her.
Roger that. Let me see. Other than that, is there anything that I need to be prepared to present or have present at time, or does it sound like I might have all of my bases covered at this stage of the process?
Yeah, it sounds like you have everything pretty lined up. The CMC is typically, I mean, it's not that big of a deal. You just need to know what your case is all about and know where you're going in the case. So when the judge asks you those questions, you can tell her or him. And then from there, the judge is just going to set trial dates.
Yeah, I looked up the judge and everything, trying to get some idea of where his, state of mind is and, what his, values are or whatnot, see if I can utilize those.
Yeah, at the CMC stage, it's probably not going to be very beneficial. Where that would be more beneficial is if you're doing law and motion stuff, like a summary judgment motion or summary judgment opposition.
Okay.
Maybe in discovery motions, but it's not at the CMC. It's not going to be that big of a deal.
Gotcha. If I could, one more topic with you.
Sure.
So last time we looked up my case review on the appeals website.
Uh-huh.
Are you able to bring that back up real quick so that I can kind of make sure I'm explaining it in the right terms?
I can try. What district are you in?
I'm in the first.
Hold on a second.
No worries.
California. Appeals Court, and your first district, you said?
Yes, sir. Let me know when you're ready for the case number.
Yeah, hold on one sec. Let's see.
Sounds like, what, San Francisco or something.
Yeah, I think it is San Francisco. So where's the...
This is the appellate court.
Yeah, I'm looking for the case number. Oh, there we go.
Yeah, it's on the right hand side.
Okay,
Little
what's
square.
your case number?
It's A 16
Oh, shit.
7
Hold on. 167
2
2
4 3.
4 3. All right. Okay.
Now, if you go to
that's
docket,
is that Contra Costa County Children Family Services VTS?
yes, sir.
All right, we'll go to what case summary docket.
Yeah, docket, and if you scroll all the way to the bottom, now, originally, they had put this on the list, the ready list, and then they made that note on 10-9 that the respondent actually requested an extension. Of course, that was denied,
Yeah.
and then below that, it's almost asking them like, we're denying your extension, but let us know when you're going to be sending in your respondent. Now, I was under the impression that you had that 30 days, then you had 15 under the extension.
Yeah.
Is there anything, like, I mean, what is what it is, I mean, what can I do? But is there any kind of motion I can file or something that, can object to them being able to allow this late in the game to send in a respondent to the brief when they're well over 60 days past, the time frame?
There's nothing that prohibits you from filing an objection, but I can tell you right now it's going to be kind of a waste of time.
What the
appellate court's going to do here is if they have good cause for the failure to timely file, then the appellate court, as long as they file their application with their proposed brief attached to it, the appellate court's going to cut them slack. But if they don't, if they don't have enough there to show good cause for blowing all of the deadlines, then no, it's unlikely the appellate court will let them file it, and they're just stuck with whatever they've already got.
Now, when you say good cause, I mean, them going on vacation or having a, large workload, does that qualify? I mean, what's
at the appellate stage, sometimes a workload or press of business can qualify as good cause, but a vacation probably not.
Got you. All right, yeah, that's what I was doing. I just felt like that, is a little unfair. I mean, come on now. If it was me, or
if it was you, they'd shit all over you. That's
right.
the way it works.
So yeah, that's all right. I'm getting comfortable with this whole life ain't fair.
Yeah.
Re-understanding for the statement itself, but
right.
Yeah. All right. Cool. I just wanted to see if there was something that I could do to, basically voice my opinion. But if it's a waste of time, I got other things to do with my time.
Yeah, it's a waste of time. It's not going to have any impact on what the appellate court does.
Does or allows.
Yeah.
All right. Cool beans.
Yeah.
All right. Well, I appreciate that insight as always.
Now, hold on though. There is one thing, because the appellate court invited them to file an application for relief, right? So you get to oppose that application when they file it. If you think it's bullshit, you want to object to it, that's the time to object. So look at the rules for responsive pleadings in the appellate court, or responsive briefs in the appellate court, and you'll want to adhere to that. I don't know what the time limit is off the top of my head. It's probably like 10 days or something to file an objection or response, and that's where you would do it, is when they file an application, or if they file their application, then you would oppose it.
Okay. Great.
Yeah.
Cool beans. Thank you, sir.
Sure. Right on, man. So questioner Michelle G and Elissa May. I think Michelle G was here first, so we'll go to her first if you have questions. Hearing nothing, we'll move on. I wasn't paying attention. I don't know who got here first between questioner and Elissa May. You guys tell me.
I don't know either. I
Well,
wasn't paying attention.
you responded the quickest. So do you have a question?
I don't. I was just kind of. I haven't been in a while, and I was just kind of seeing how everybody was doing.
Oh, cool.
I'm still waiting for the judge to respond to my motion to dismiss.
Wow, that
We're
was
going
a,
on like 7 months now.
yeah, that was a while ago.
It was. We're still waiting, so
Well, if it makes
that's
you
all I got going on.
if it makes you feel any better, I had one. It's Hipschman versus County of San Diego. It was fully briefed back in Jesus.
February?
Yeah, like February.
Wasn't it?
I think it was February. We just got the decision like 3 or 4 weeks ago. So
Oh boy.
yeah, 8-10 months. That's not abnormal.
Yep. So I'm just waiting,
Yeah. Sorry, that's just how it goes, man.
right?
Yeah.
Hopefully soon.
What?
Oh,
Wow. There's like a lot of feedback on whoever's talking. I can't understand a word you're saying.
Yeah. Yeah, Sean, that's me. I don't. I'm gonna have to get some. Yeah. Sorry. So listen, following on heck real quick. Here's my question. Here's what I ask. You know,
Yeah, it's whatever you're just coming through garbled.
okay.
I heard that. I heard okay.
So, in the Florida case, I got dismissed. I got a Florida case dismissed. It's summer, Sean. Oh, you hear me? No, you're shaking your head. Yeah. I'm going to type this in. See if that'll work. I'm going to type in the question. What do you think?
I'm not catching what you're saying. It's just way too garbled. I don't. I.
You can type in the question.
Saying that he's going to type the question in.
Oh yeah,
And
type it.
I'm
Try
just
that.
wondering
Here we
if I can ask my question while he's typing.
Yeah, you can do that.
Okay, so here's my question. There is a trial, and at the trial, I present photographs, video, documentary evidence, eyewitness testimony of X, Y, and Z. And I argue that X, Y, and Z constitute abuse and neglect. Then the court writes a 12-page memorandum order decision. And the memorandum order says A, B, and C are not abuse or neglect, where A is a misstatement of X, B is a misstatement of Y, and Z is a misstatement of C.
That's too much algebra. That's way too much algebra for me. You need to make that a little simpler.
Well, I'm trying to do that because last week we got all into what the specifics were. I said that all this stuff had happened and that it was abuse and neglect.
Okay. And the judge
And
and the judge disagreed with you. Said, "No, I don't think that is abuse and neglect." Right?
No, that's not
Okay.
it. That's not the question. I said X, Y, and Z are abuse and neglect. They said A, B, and C are not abuse and neglect. They didn't say anything about X. They didn't say Y. They didn't say Z was not. They just distorted and scrambled and misrepresented what I had said.
Okay.
Said that's not abuse or neglect. Are X, Y, and Z res judicata?
It would depend, I think, on whether or not they're a necessary element of whatever claim was adjudicated. If they're not a necessary element, then probably not.
Oh. I think I need you to explain.
Okay, there's a case you need to look at. It's called Lucido v. Superior Court. Lucido v. Superior Court. That will give you everything that you need to know about res judicata and collateral estoppel.
Okay. But I think what I don't understand, listening to your answer.
Sure. Oh, before you get into that, let me make sure, because a lot of these people are litigating stuff in federal court. Lucido is a California state cause of action. So it may still have application in federal proceedings, because depending on what you're doing there, the federal court may still look to California or your state law for your elements of collateral estoppel or res judicata. But that's going to be dependent on where you are and what your issue is. But if you're in state court, Lucido is the binding authority.
Okay. So, but your question makes me think that I am not understanding the difference between findings of fact versus claims.
Right.
Because I think in order to fully understand your answer, I have to understand that, and I'm not sure you're saying were the facts that I pulled that they didn't really render judgment on, are those essential to the claim?
Right.
And actually, what did you even say?
Yeah, it's what the facts that you're worried about, were they essential to elements of the claim, or are they just collateral facts that don't really matter to the outcome? They're not essential elements. See, every cause of action, every claim, whether it's by statute or otherwise, is made up of elements. Like the classic example is negligence. Well, what are the elements of negligence? There's got to be a duty. That's one element. There's got to be a breach of that duty. That's another element. There's got to be damages of some kind. You have to be harmed by the breach of that duty. And then there has to be causation. That the breach actually has to have caused that harm. Those are 4 elements. Now, each of those elements are composed of facts. It's going to take facts and evidence to prove each element. So that's what I mean when I say, was it an essential fact, essential to the proof of some element of your claim? And if it's not, then no.
I think it was essential because, quite frankly, I agree that the things they said were not abuse, are not abuse and neglect. They didn't render judgment on the facts I presented. Render judgment on some distorted version that was distorted beyond recognition almost. Oh,
well, that sounds though like it sounds like you're not satisfied with the factual findings that the judge made based on contested evidence. I mean, you put up your evidence, the other side put up their evidence, you guys don't really agree. The judge has to make a decision, that's his job. And it sounds like maybe you're just not satisfied with the way he went with his decision.
No, I'm not satisfied because
right.
he didn't say it. I mean, I wouldn't be satisfied anyway if he didn't agree. But if he said I said X, Y, and Z happened, and he didn't say X, Y, and Z aren't abuse and neglect. He said A, B, and C aren't abuse and neglect. Well, that's not what I said. That's why I'm.
Did you request a statement of decision?
Did.
And did he give you one?
Oh, an argument whether that memorandum order, the 12-page memorandum order, was a statement of decision, but it certainly didn't address any number of issues I requested that they address.
Okay. Did you get your appeal timely filed?
Did.
Okay. Well, then that's your remedy. And if you've timely filed it, then that's kind of the end of the story. You just got to wait and see what the Court of Appeal does with it.
They already it went sideways.
Okay.
The appeal is, and I did this United States Supreme Court thing, but not really expecting much.
Yeah, those things don't really make it. They only take like 3% or less of the cases that come up to them, and those are generally, not always, but those are generally a waste of time.
That's why I'm asking. I appealed, but the appeal went sideways, and it's basically over. I suppose the United States Supreme Court could surprise me, but is the status of those facts were never adjudicated? What I'm saying.
Well, I mean, again, that's the question isn't whether or not those particular facts were adjudicated. The question is whether or not whatever facts you're worried about were essential to whatever it was that was adjudicated, and it sounds like they were not essential. So I guess the answer to the question is, so what if they were never adjudicated? If they're not essential to the outcome of the case, they don't matter. They're immaterial.
Saying they were essential.
And did you argue to the appellate court that they were?
The appellate court never got to my. There was issues with they cut me off with I didn't have enough time. They didn't read my brief.
Oh, I think I remember that. You didn't have enough time to get it timely filed or something.
Yeah.
Yeah, that sucks. I don't think any of that's going to matter. I think that you are stopped. If you
You
had
see what
an
I'm saying?
if you had an
You stick it to
opportunity,
the little guy.
yeah, if you had an opportunity to fully, litigate your claim, and it sounds like you did because you put your evidence on in front of the judge and he found against you, then take a look at Lucido, and I think you're going to find out that, yeah, you're barred.
About the same versus facts versus elements versus claims.
Say that all again, because somebody was off mute and it was giving feedback and sort of drowning you out.
Facts versus elements versus claims.
What I heard was facts versus elements versus claims. I didn't hear the first part.
Well, how do I? Am I going to learn about that if I read Lucido?
You should.
Okay. Okay. Thank you.
Yeah, Lucido's the answer to your questions. I think when you take a look at Lucido, that's, unfortunately, I think that's all going to resolve against you.
Okay. Not good news, but thank you for answering.
Yeah. Yeah, no problem. All right. Anybody else? Who's up next? Don, I didn't see your stuff appearing in the chat. Are you still there?
Yeah, I am here. I've typed it into the chat. Have I not? I'm looking at it. Man.
I don't see it. Does anybody else see it? Did you put it in the chat for office hours, or did you put it in the chat for general? Let me go to general and look what's there.
You're commanding.
Say that all again. I didn't hear a word you said. Just heard.
So you're so demanding. Dude, I have no idea how to put the chat into the. Let me.
Yeah, no. You're not coming through, man. It's coming through really loud and garbled and unintelligible, but it's loud enough that it's painful. Are you on a laptop or a cell phone?
Desktop.
Yeah, maybe it's just bad internet or something. Sorry, Don, man, but we're not going to be able to work it out with you on this one. I don't think you might. I'll show you guys the mic I got here. You can probably sort of see it. I got that on Amazon for $40, and I'd recommend if you have trouble with the mics or whatever, is get one of the mics on Amazon. Those things actually work pretty well, and they're highly adjustable and tunable and all kinds of stuff, and they're cheap, and then you don't have these types of problems. But yeah, I'd highly recommend it, because whatever you're working on tonight, it's not working out. Sorry, man. And I'm not seeing you in the chat. I don't know where you're chatting. So I'm looking in the user panel, and I don't see anything anywhere. Let me look at this one and see if that's D Cook. Are you D Cook?
No, I'm showing. I'm Don is my username here in office hours.
I heard. Oh, here we go. Yeah, you're not in office hours for the text. I found it. I found the text. You're actually did the text in the general text channel, but that's okay. I'll read it, and I'll read it out loud. That way, everybody gets the benefit. It says, my heck question. Recall, I got my Oklahoma removal case dismissed this summer. I defended two parents. I found a brazen instance of judicial deception. Good facts for 1983. However, the prosecutor filed a felony abuse case against my dad 4 months before the dismissal and appears to be prosecuting it anyway. That's interesting. So if my dad were convicted of a felony on the same facts, would the 1983 be a stop per Heck? Well, that's going to be a question of who's bringing the case. Who's the plaintiff in your case? I don't know if you could hear me or not.
So, as the plaintiff in my potential 1983, that would be one or both of the parents and one or both of the children removed, right?
I clearly understood the word parents and I clearly understood the word right. Everything else was kind of garbled.
So the plaintiffs in my 1983 would be one or both of the parents and one or both of the children.
Okay. So I don't know that Heck's going to apply because Heck is only going to apply to your plaintiff, right? And you might consider. Oh, well, actually, he hasn't even been convicted yet. It looks like they're trying to convict him, right? So I don't know that you have a Heck issue anyway. Heck is only going to apply when there's a conviction, right?
Of course, if you read the rest of my text, you're right. I concede that he has not yet been tried, but if he were trying the fucking felony, he would walk. Trust me. But he can't hire me. He can't afford to hire me, and the public defender that would hire him is useless. So I'm worried about a conviction.
Okay. I think I understood what you're saying was that Dad can't afford to hire you for the criminal case, but the public defender sucks, basically. And you're worried that there will be a conviction of some kind, and then that would act as a bar for Dad's 1983 claim. Did I get that right?
Ding, ding.
Say that again.
Ding, ding, ding. Yes.
Okay. Okay, so I guess the question is going to be the criminal conviction. Is it necessarily parallel or involve the same facts as your 1983 claim? What's the criminal conviction for? Same facts, okay. Yeah, I don't know, man. That may end up being a problem not only for Heck but also for collateral estoppel, right? Well, I don't know about collateral estoppel because you're in Oklahoma. Your rules may be different, but I would have concerns about collateral estoppel, and I would have concerns about Heck. But you have arguments. I mean, I've got a what case was that in? Shit, I don't remember. I had an appellate argument, actually. I think it was Fogarty Hardwick, actually. I think that I have appellate briefing in that where we addressed the Heck issue. They were pounding the hell out of Heck because it wasn't a criminal conviction. It was a, essentially similar to a criminal conviction in the juvenile dependency court. It was a finding against her and on the facts. And they were arguing, the county was arguing that, hey, look, Heck applies because this is analogous to a criminal situation. It's like, no, it's not. By statute, it's civil. And so those were the arguments there, is that Heck doesn't apply to a civil situation, and the appellate court bought it. But I think that's the only briefing I've got on Heck. My dad has some briefing on Heck. Do you have briefing on Heck on your case?
It came up and I don't remember. It didn't amount to anything, whatever it was.
Yeah, I'll look. If you shoot James an email at capsonstemslaw@gmail.com and remind him to remind me, I'll get my dad's stuff. That's probably going to be more applicable because you have a criminal issue going on, in parallel. The Fogarty stuff may be meaningful for you, but I really don't think so. We might have done we might have had a Heck argument in Kasdan too. I don't remember. I know we've actually had to deal with it several times. but I'll have to look for it. But I'll get you some briefing if you can shoot us an email and just remind me. And yeah, Don, I see your comment here. It says, but in your case, the BOPs are way different in removal. You know, preponderance versus felony is beyond reasonable doubt. That's true, and I'm not sure necessarily what impact it's going to have, because if he gets a felony conviction beyond a reasonable doubt, it's a lot tougher to get than preponderance. And if I were the other side, I'd argue, and I think it's a good argument, that you've got some collateral estoppel issues there. I see your next comment is meaning ... and while you're figuring that out, I'll look at meaning a finding that the removal was unfounded. Yeah, I'm not sure that the finding that the removal was unfounded in the Juvie case, since it's a lesser burden of proof, is going to be helpful for you in the felony case, right? Because I don't know if unfounded in the civil context is going to be res judicata, right? Just because of the difference in the burden of proof. I don't know how that stuff works in the criminal, but if I don't think they're precluded because there's a different burden of proof. If you were in California, I'd tell you to take a look at Lucido. I haven't looked at Lucido in a while, but I seem to remember that there is an issue with the burden of proof where you're stepping up. Yeah, that's a good point. He says, for those of you that aren't looking in the correct chat, says if the state can't prove it by preponderance of evidence, how the hell can they prove it beyond a reasonable doubt? True, but for the argument on the collateral estoppel issue, I think that a difference in the burden of proof is one of the elements that you can look through to say, hey, look, this should not be collaterally estopped. So I don't know, man. I think that that's a good argument, though. Also, there's going to be another issue, and that's that, at least out here, I don't know how they do it in Oklahoma, but out here, the juvenile dependency question is going to be resolved by a judge, not by a jury. And whether you have a jury or judge will also make a difference out here in the collateral estoppel argument. They're gonna look at multifactorial. There's like 5 elements, and 2 of those elements have sub-elements. And as I recall, burden of proof is like one of them. CE is issue preclusion. RJ, right, is claim preclusion. That's correct in the federal context. Is the same claim as the related felony. Yeah, I think that you got to look at your state law in Oklahoma on res judicata and collateral estoppel. That would be my feeling on it. You got to look and see how your state law is going to deal with that issue. Res judicata, yeah. It doesn't necessarily have to be claim preclusion, though, right? If some of the issues, that is, some of the ultimate facts, are resolvable or resolved by collateral estoppel, they don't necessarily have to resolve the entire claim using collateral estoppel. Just certain issues could be resolved, which essentially is elements of the claim. In B, I'm not sure who that is, but there's another question here related to Don's question. It says, if the 1983 suit necessarily implies the invalidity of the conviction because of litigating the same underlying facts, then it could be barred. Yeah, that's correct. But there could be a lot of leeway depending on the exact facts and cause of action litigated and the difference between dependency proceedings and criminal proceedings. Yes, that is correct as well. I could imagine scenarios where the judicial deception would be material to a removal, but not to a probable cause or criminal conviction. Yeah, I would agree with that as well. Or the 1983 cause of action has no bearing on the criminal conviction. Yeah, that's all correct. I would suspect that in B, whoever that is, has dealt with one of these things before, or is an attorney that's actually, yeah, probably dealt with one of these very issues before. That is my guess. So who are you in B? No response.
It's a mole. I'm just kidding.
Yeah, probably a mole. I don't doubt it, man. But that sounded correct to me. In NB's analysis, that sounds correct. Yes, Think Missa. That is my dad. He's sitting off here to my left.
I'm leaving.
And he said, this Think Missa says, tell your dad I said to tell you to take my case. It worked for Deanna. He's leaving.
But you learned your lesson.
Yeah, he said I learned my lesson from that. You all right?
I'm trying to get up without knocking all your crap off.
Yeah, I gotta clean all that shit up.
I made it.
Yeah, I've got a
So you
mess.
keep it in there?
Huh?
Is it still in that box?
What? Oh, this? Yeah, this is frickin'. You're ready to go spawn bag, man.
What
do you- What
Used to
box?
be in the attic.
Oh yeah, no, I think that I don't know. You can check, see if there's a gun in there. I don't know if there is or not.
Nope, it's gone.
Yeah.
What'd you do with it?
Oh, I know where it is. It's I've got a lockbox somewhere. I've moved it
That
into
does
a
you a lot
lock
of good.
case. Yeah, I know. I don't actually know where the fuck I put that thing. Actually, yeah, it's around.
Might need it someday.
Yeah, could.
I'm gonna go.
All right. Good night.
Night.
So what's Senior McMillan doing in the office hours tonight? He's making sure you on point, keeping you T's crossed and his I's dotted.
Yeah, he's just sitting there and saying hi. He came over for some exercise. He actually lives right down the street from our office. I grew up in this neighborhood. And,
Nice.
you know, once I started practicing law and the kids got old enough to go to school and then I had to drive them all over the place, it was really inconvenient to have an office not close to a school. So I ended up getting a place here just down the street, 3 or 4 blocks from where I grew up. And it's got good schools. They're all convenient. So the kids went to school here and I just did my work. Now they're all grown up and abandoning me. So I don't know what I'm going to do with this.
Such is life, eh?
Yeah, it's the natural order of things, man. Yeah, Miss, I don't think he scared him away. I think he was just getting bored because the headphones were on to avoid feedback, so he couldn't really hear a lot of what was going on the other end. Although he did hear Dawn when the garbled stuff started coming through. It was pretty loud in the headphones. He's all, "Wow, that's pretty bad." But yeah, Dawn, you gotta get a mic or something, man. That's a bummer. I mean, I think that you've got a lot of good stuff to talk about, but I can't hear you, and it's really hard to do it on the chat. But shoot us an email for the hex stuff, and I'll send you the briefing that we've got, and we may have some up there. Oh yeah, okay, I know exactly who you are, Don Haslam, right? Okay, let me copy the email. Copy. And then what I'll do is I will see what I can find for you tonight before I split. And Hecky Humphrey. Yeah, I'll see what I can find for you in terms of briefing tonight before I split. And I'll send you what I've got. Yeah, no problem at all. I'm still curious who NB was. I was charged and ultimately all charges dismissed, brought suit including malicious prosecution, judicial deception, wrongful removal. We're arguing that heck doesn't apply because the ongoing charge is told. So similar but different. Yeah, I'm very curious. NB, who is that? Oh, okay. Nigel, got it. All right. Well, Nigel, you're kind of up to speed on heck, man. Everything you were saying in your comment, I would agree with your analysis. That is correct. But I'm trying to think where I've got briefing on it. I'll figure it out for you guys. What we'll do, actually, since there's 2 of you that are dealing with this, is I will find it and we'll get it posted on Patreon. And yeah, that should be. But I'll email it to you guys anyway. But there may be other people out there that end up struggling with this issue, so we'll get heck addressed. Oh yeah, I know, man. It's all right, Don. It's all good. Just get on Amazon. They have the cameras, the mics, all this stuff is pretty cheap. It's really not it's not that bad, and it's pretty high quality. I mean, I listen to the videos. I don't know really how it sounds on you guys' end, but I listen to the videos, you know, when James publishes them, and I don't hear anything. It doesn't sound bad. So, you know, for $40, it kind of worked out. Talk to James. Talk to my son. He can get you hooked up with this stuff. He does a lot of stuff online or chat, whatever. Does a lot of tech support for, you know, attorneys that we work with. He does all our IT stuff. He's pretty dialed in. If you're having issues, give James a shout, and you know he may be able to help you out. Yeah,
Sean?
does. Yes, ma'am.
What is the statute of limitations on Monell claims or judicial deception claims?
It's going to be the same. Remember, any claim under 42 U.S.C. Section 1983, unless it's told, unless the statute of limitations is told, it's going to be determined by whatever state you're in. I know you're in California, but there's people all over the place listening. Whatever your state is in, or whatever state you are in, the law of that state with respect to your general statute of limitations, which is typically your general negligence statute of limitations, is what will be the statute of limitations for your 1983 claim. So in California, our general statute of limitations is 2 years for negligence. So that's the statute of limitations here, is 2 years from the date of the bad deed. Or, you know, the correct way to term it would be 2 years from the date the claim or cause of action accrued, first accrued. In, you know, simpler terms, it's just whenever the bad deed happened and you suffered an injury. So that's basically it. Generally speaking, in a warrantless seizure claim, it's going to be 2 years from the moment they seized your kid without a warrant. In a deception claim, at least against CPS, it's going to be 2 years from the first time you discovered they had lied about you. And discovery is going to be like when they file their documents with the court, because you know you get a copy of that and you're able to, it's when you knew or should have known. So you're able to get the document. If in the document they say, oh yeah, Dr. Gill said XYZ, and you know who Dr. Gill is, you have the ability to call Dr. Gill and say, hey doc, did you really say this stuff? Then you know you should have known. So for all intents and purposes, your 2 years is going to run from the date they provide you that report.
What about Monell claims?
Same thing. It's 2 years. See, remember a Monell claim, it's the case that determined that municipalities are subject to 42 U.S.C. Section 1983 was Monell versus, what was it, Department of Social Services, like New York or something. And basically all that came out of that was the Supreme Court said, oh, yeah, we're going to determine that a municipality is a person for purposes of 42 U.S.C. Section 1983. That is all that happened there. They didn't create a new species of tort or anything else like that. They just said, yes, 42 U.S.C. Section 1983 applies to cities, counties, water districts, you know, government agencies, not the state, though. The 11th Amendment, you know, bars that. But as to individual government workers and the municipalities, districts, things like that, counties, then yeah, 42 U.S.C. Section 1983 does apply. So it's not really its own species of tort. It's just a 1983 claim, but it's against a county or a state or a city or a district, you know, or a government hospital. Sometimes you see those under 1983. So it's just a different category of defendant. It's not a different species of tort claim. Does that make sense?
Yeah. Can a probate department of a state court be a defendant in a Monell claim?
I've never examined that. I don't know where the case law is going to fall down on that, but my gut feeling would be no. And the reason I say no is because the state court is the state. It is not a municipality. It is the state of California. It's the judicial branch of our tripartite government. So I would say no, you probably cannot bring a Monell claim against the state. Yeah, that makes sense to me. You get 11th Amendment immunity, right? The state can't be hauled into federal court to face,
Okay.
claims based on federal statute.
About like the individuals who are
Well,
training.
it's a different story. Remember, like Pellerin was a good example of that. Is that 11th Amendment immunity applies to the state for sure, but the individual government workers are totally subject to not Monell, but 42 U.S.C. Section 1983. So yeah, you can sue individuals for violations of either federal law that generates a private right of action, or for constitutional violations, federal constitutional violations.
Okay, or maybe the better question is, no. My hypothesis is that there's no training going on for if you have a disabled person, how you have to accommodate them.
Mm-hmm.
I would bet money that there's no training for court personnel on that, or almost no training.
I'd agree with that.
Training.
There probably isn't, but that's an ADA issue, not a 1983 issue. That's either voc rehab or ADA. I don't think that's going to be a 1983 issue. Did you ever talk to Richard Prager?
No, it's on my list of things to do. I had to won't go into it. He's on my list.
Yeah, I would talk to him.
Okay, so I was thinking that it was a Monell claim for failure to train out ADA.
No, I think it's just gonna be an ADA claim against the entity, and then the failure to train is going to be part of the ADA claim. In fact, it's probably going to be some evidence that you would use to prove up your ADA claim.
So, but would the state be immune? Because it was, but I guess I can sue all
I don't think the state's immune from it. I don't know if the state's immune from ADA or not. State is certainly not immune from UNRU, and that basically incorporates the entirety of the ADA by reference. So that's an issue I'd talk to Richard Prager about. That's like right up his alley.
Okay. Thank you.
Yeah. Yeah, that's all he does. He only does ADA stuff. So anybody else? We've gone a little bit over tonight, but I'm gonna have to get cut loose here pretty soon. I'll take one more. I don't think that Nigel or Michelle have asked questions. Neither has Lissa May. So if you guys have anything, now's the time to speak, or forever hold your peace. All right, man. Hearing crickets. Oops! What the hell? What just happened? There we go. Hearing crickets. I'm gonna go ahead and call it. You guys have a wonderful rest of your weekend. We've got a problem on Restream somehow that's blocking my IP address. So James is going to work on that tomorrow night some more and try and get it worked out. But until then, he's streaming the videos, and they're still going forward. But I'm not on them. Not that that's any big loss. I don't know that I have a whole lot to add anyway. These things were done years ago, and I don't know how good my memory is. But it's kind of weird not being on them. But anyway, James is going to try and work on that and get that worked out. Regardless, the video will be going tonight as regularly scheduled. Just I won't be on it because we're still having technical problems. So with that, I will say adieu and you guys have a wonderful evening, and thanks for joining us tonight. I hope that everybody got something out of it. Had some good questions tonight. I'm going to have to go study up on hex. I just don't remember. I know that we've had to deal with it a bunch of times. It's just been a long time since I've had to do that. I just don't remember it. So I will bone up on it for next time and have something to share. With that, you guys have a wonderful evening. Thanks for joining us, and enjoy the rest of your weekend, whatever's left of it.